powers. Okay, if you get limited powers, then it makes life much more difficult through probate. But you know, so you have a good attorney, you get your full powers. After that, you begin to gather all the assets and figure out what the estate, either your parent or whomever it is estate you're administrating had. And then you have to value those assets, and that's a very, very difficult process that can get expensive too. Especially if there's personal property that's expensive, cars, classic cars, homes, things like that. Certain property have to be sold. So you have to start the process of selling property, and if you don't have a good lawyer, they may not know all the ins and outs of getting you around a forced sale. There are ways to not sell a car, or maybe not even sell a house if you don't have to. Now if you do all that, you have to distribute, and that involves another hearing of the court and making sure that the distribution is according to the decedent's wishes or according to statute. The main issues with probate is the expense. I had, the worst case I've ever had is a mother who was murdered. She had 2 small children. She was murdered in a killing spree in this apartment complex. I think 4 of the people got killed. And I was in court doing a probate on an entirely different subject. And she, is this being video recorded?
Yeah, do you...
Okay, I just got to be a little bit more careful.
If you want, I can stop. I don't have to video it.
No, it's okay. I can be careful.
Okay.
So she, I met this person, and she was having, I could hear her in the courtroom having so much trouble with this. And when she came out, I said, hey, do you need any help? She said, you know, I've been doing this probate for almost 4 months, and it's driving me crazy, and I keep getting rejected. So I came on board, and by the time we finished the case, the decedent only had a house that was worth maybe $300,000, $400,000, and then maybe $25,000, $30,000 and everything else. There wasn't much there, cars and a couple of savings account, a little life insurance. And this probate ended up costing the kids $50,000. Okay, so that is why it's very, very important, and it took almost 2 years. Okay, so that's why it's very, very important to have an estate plan in place. The other thing is it's very lengthy. Like I said, it could take up to 2 years. I've been able to slam dunk and expedite probate for like 8 or 9 months and get it done really quick. But those are under strong circumstances. It's very complex. That's why you have to get a lawyer involved. And of course, the costs go up in that regard. And it's very frustrating. It causes the beneficiaries and the executor administrator a lot of stress. It's a very provocative environment. It's a very provocative procedure. And what it does is it causes a lot of strife between beneficiaries. So I have seen siblings who got along okay through many, many years, all of a sudden hating each other and really wanting the worst for each other and hiring their own attorneys. And I've actually probably mediated between siblings 7 or 8 times and helped them resolve insanity that they didn't used to have before. It's a very forced process, so there's fire sales. So a property that would otherwise be worth $500,000 might be sold for half of that or $250,000. And you lose a lot of control. The wishes of the decedent may not be carried out through the court system because you're deceased. Any questions on that? So there's also, yes?
Supposing all the assets are individually beneficiary, you know, like bank accounts and so forth, if they're all individually managed, how does that work? Where does that lead?
Bank accounts are okay. You can get around probate with just bank accounts, but you know, real estate gets a little tougher, and other personal property gets a little tougher too. So with real estate, what a lot of people do is make a joint tenancy with their kids or something like that, or give it to their kids. But that triggers gift tax rules that you have to be really careful about. Also, if there's more than one kid and you don't title the property correctly, if God forbid one of the kids dies, people don't know that the other kid could get everything, and then your grandchildren are left out. So it can get tricky, but there are Yeah, there are other strategies you can also implement. Okay, so what's a will? A will, the only thing a will is instructions to the probate court. So will still gets probated, but it's instructions to the court. So what it helps you is with that last thing on the list, which is control. In other words, it helps the court make sure that your wishes get carried out. Okay. Then the other thing is, in case of incapacity, you could need a conservatorship or a guardianship, which is incredibly expensive. And it has all the problems that are here. It's a very lengthy process, especially for conservatorship. And of course, if people have minor children, like I do, then guardianship becomes a big issue. We had to do not only a probate for this murdered mom, but we also had to do a guardianship on the side for her 2 kids, and that was a whole other process. In fact, I did the guardianship pro bono, and I waived my fees for the probate in lieu of the house being sold. So nobody's paid me anything, and as long as they own the house, they're not paying me. But if they sell the house, then I get my attorney's fees. So I tried to be as generous as I could with that.
So what is the definition of conservatorship?
That's if you're incapacitated and you haven't named anybody as you're having durable powers of attorney or healthcare director over you, then they name somebody to take care of you.
So
it's a legal.
You put that into a trust then?
Yes, you can name a conservator.
Is that why you mentioned it?
If you have a durable power of attorney and a healthcare directive, you normally don't need a conservator. But you still might. You still might. And when it comes into effect is if somebody disputes that and wins in court, and then the court has to name a conservator. Okay, that's one of the ways. That's the most common way. And in that case, you name who you want to be your conservator in your trust. Your trust package. So even in that case, you get the right conservator. Whereas it could be a court appointed or somebody you may not have wanted. Okay, so what's a trust? What a trust does is it avoids probate. So it allows your beneficiaries to get all your things without all these hassles. And to understand what a trust is, you look at my trust pricing sheet on the next page. And of course at the top it goes through my pricing. And on the back of that I put a 20% voucher that everybody here gets, and you could use that. And then you can calculate your own price from this. It's pretty simple. You take 20% off of that. Now, one of the great things about our trusts is we do our trust from A to Z. What I like to say is when we're done, you're done. A lot of law firms, what they do is they give you your trust, and they either don't help you execute it or sign it or notarize it, which is what we do. But even worse, they don't help you fund it. Funding a trust is almost half the work. Okay? In other words, changing the title of all your assets and life insurance beneficiaries and annuities and all that appropriately into the trust. Okay? And our trust pricing includes everything. So what I say is when we're done, you're done. A to Z. Okay? So what does a trust include? It includes the revocable trust, designates beneficiaries, your trustees, guardian of your children, asset distribution, of course, timing. If you have minor children, normally they would get everything at 18, but you could time that out throughout their life. Let's say you have a special needs child, or you just have a kid that you don't trust entirely at the age of 35 or 40, you can bring it out to age 50. Your beneficiaries avoid probate, and there's some tax benefits. It also includes what's called a pour-over will. What a pour-over will does is, if there's any assets that, let's say we do your funding, okay, and we're done, and then you buy another asset and you forgot to come back to us, so we fund it for you, a pour-over will fund it for you after you're done. It makes the funding into your trust a lot easier. And of course, it also names...
What's the word, portable will?
Pour over. The way you
Pour
could,
over
yes,
will.
yes,
Okay,
you could think
good.
of
Okay,
this
thank you.
cup as your trust, and think of a
Yeah.
saucer under it as the
Pour
will.
over, okay.
What it does is, if there's any assets that don't get
Yeah,
caught in there,
okay.
it'll pour them in there. That's why they call it that. Okay. Then it has durable powers of attorney, first for financial management. So God forbid if you become incapacitated, let's say you get in a car accident, God forbid, for 8 months. And 8 months you're in the hospital, but you're going to come out of it and you're going to be happy and healthy afterward. But in those 8 months, who pays your bills, who talks to the insurance companies for you, who talks to your mortgage company for you, that's your durable power of attorney for finance. Excuse me. The other one is called the Durable Property for Healthcare, which is California Public Health Care Directive. Okay, and that is you designate agents to take care of decisions with your doctor or your hospital. Okay, it's pretty much the same thing as finance, but healthcare related. And that's very, very important because you get to put in there what your resuscitation instructions are, what your home health care restrictions are, convalescent home health care. So you get to give all the instructions that you want so your loved ones, you don't have to make the arduous decisions for you, or worse, have to go to court to get the power to do that. And of course, most importantly is after we're all done, you come to our office, you sign it, I notarize it for you, and then the funding process starts. It actually takes longer and is almost as much work as the trust itself. Okay? So that's that, and there's some fine print down here, and if you have the 20% coupon, so if you want to go back to the first page, we can finish up real quick. Any questions on that?
I have a question on something else.
Sure. As long as I know the answer, I'll try to answer it.
Well, this might be difficult to answer, but if there's assets in another state, and you're in a same-sex marriage in California, and the other state doesn't necessarily recognize that, where does that leave you with the assets in the other state as far as the marriage is concerned?
It leaves you really, really needing a trust.
So
Because you can't.
do states respect each other's line of
Well, that's why they
inheritance
passed
or-
the Federal Protection of Marriage Act, which could still be found unconstitutional. I think the lower court found it. I think the state court found it. I don't remember all the details, but anyways, one of the states has already ruled on it. It went to the state Supreme Court that ruled on it, and now it's going to the United States Supreme Court. And you know Prop 8, how the Ninth Circuit District Court of Appeals, it actually didn't hear it, which meant it upheld the lower case, which said it upheld the trial, which said it nixed Prop 8, which is good for us. But one of the things the Supreme Court is deciding right now is whether to hear the Prop 8 thing first, if at all, or to hear this Federal Defense of Marriage Act first. So that's one of the things they're deciding. So that being said, the best way to do that, a lot of people do what's called joint tenancy or tenancy in common. That has its pluses and minuses, but it's very limited in what instructions you can give. But a living trust will alleviate all that. Okay.
I have a question. Actually, I have a few questions, but I'll only ask one. I work with a lot of mothers that are aged, 70, 80, one is even 95, and they have adult children who suffer from chronic forms of mental illness. And so I noticed you mentioned a special needs trust. Would that be the tool that you would recommend for them?
Very likely, I would.
Because
In
they all
fact,
have a house.
have you seen my badge? I'm president of the board with Bridges to Ability. It's
Oh, I love Bridges to Ability.
Yeah,
Oh, I
I'm
have
president of the
I
board
have
with them.
3 clients in that program.
You know,
It's wonderful.
we have a
What's Bridges
contingent.
to Ability?
We help adults and seniors with developmental disabilities.
It's
And
recreation, socialization,
sports.
life skills. It's a wonderful program.
Exactly.
For DDs.
We just started an
Here's
ice
the
hockey
problem, we
league.
have almost
DDs
nothing for MDs.
Well, these DDs with MH, if MH is secondary.
Well, what I'm trying to tell you is I'm learned in this regard.
Oh,
Okay, so I
well,
know
thank
this
you.
stuff, and yes, special needs trust could be one of the ways you do it. Okay, and there's also Medi-Cal considerations, all kinds of crazy
Yeah.
stuff. You probably honestly know better than I do, and I'm probably going to call you.
Sure,
Okay.
please do.
But those are all the different concerns. But yes, a special needs trust is on top of the list. It's on the short list of things in those situations. Okay, because you don't want these wonderful people getting money as an adult, which they would just blow.
Or get exploited.
That's right. Or get exploited. Absolutely, I've seen that.
Yeah.
Question, irrevocable versus revocable, what are the reasons for the two?
Sure.
What are the
Well,
considerations?
there's 2 main reasons, and that's, I guess, the next 2 we're going to talk about. Taxes and asset protection. Revocable trust, which is what we've talked about so far, don't give you almost no tax and asset protection. Okay, in other words, against judgments or bankruptcy or anything like that, or getting sued or creditors and stuff. Okay, so what the IRS and the legislature has done is said you can do your trust, and the more control you give up over your trust, a revocable trust, you maintain full control over everything. Okay, so you can put property in, take it out, sell it, whatever you want to do. It's as if you still own it. Okay, the more of that control you give up, the more of these two things you get in benefits. So in other words, the more control you give up, the more tax benefits you get in your trust. The more control you give up, the more asset protection you get in your trust from creditors and judgments and things of that nature. Okay?
Give up control in what way?
Over the property in there.
Revocable or irrevocable?
No,
Yes.
So
what
the
I
more
mean
you
is,
make it revocable, the more
The more
tax
you make it
advantage.
irrevocable,
That's right, yeah.
right.
Are you
Irrevocable,
saying
the more
that-
tax
Control
advantage.
over the corpus or the
Are you
property,
saying-
assets in the property.
are you saying that then the administrator has complete control over it? Is that what you're saying? After you die, that's giving up control, or?
No, while you're still alive. Let me give you an example.
Okay,
Let's
what
say
I'm-
you do a
what I'm
charitable
asking-
trust.
What I'm asking is, a lot of people have very exact parameters in their trust. So are you saying you can't do that? Or
If
are
the trust itself is revocable, those parameters can be changed, so it's revocable and you get no benefits for that. But if you make those parameters irrevocable, then you could get some benefits, whether it be tax or asset protection.
I guess what I'm saying is, there's two kinds of control. If you're saying that it's all preset, but it's still totally controlled, that's what I'm asking. If you set down the language and it's just unbelievably restrictive, but it's set down language and then it's frozen in time, is that what you're saying you can do? Or are you saying that with an irrevocable trust, you have no control over it at all, you just hand it over to an administrator and then...
There's different levels. You can give up more and more control to get more and more benefits. Okay? It's kind of like a novel. At 0, you have full control, but you don't get any tax or asset protection. You can turn it to 1, you get a little bit. 2, a little bit more. 3, and the higher the number, the more control you're giving up over your assets in your trust. I'll give you an example.
If it's irrevocable, you can't, once it's in there, you don't get it out.